Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's stream, we're reviewing a leaked document relating to Nick Rekieta of Rekieta Law. As I'm sure you're well aware, Nick Rekieta's house was recently searched, and 26 grams and change of presumptive cocaine, as well as other items, were found and seized. And of course, as part of that, the government is also looking to modify potentially his relationship with his kids. I don't know where that will end in the end, but I presume in the end that this will not result in any permanent problems, but it's definitely going to result in some temporary problems for sure, and potentially several months to years of child services involvement with certain things. But I don't think they're going to go out of their way to separate the kids from the parents on a permanent basis, but that would be my presumption. In any case, what we have for the moment is some findings of fact and conclusions of law relating to the emergency protective hearing. So the government filed for an emergency hearing due to the necessity, and they got an answer back from the judge, as you would expect, in an expeditious fashion. So this is a preliminary hearing, if you like, and the judge has issued a preliminary order that is obviously subject to modification down the road. And we will look at the order and what it has to say, and we will discuss this as best we can from a legal angle. So let's go ahead and get started with that. So this above matter was held before the judge on June 6th. Not clear, incidentally, how this document came to light. Not clear who leaked it. Not clear when they had it. I will take note that it's almost 2 weeks later. So I'm not sure how long, if at all, someone's been sitting on it. But this happened 2 weeks ago. And it happened in Cuyahoga County in Minnesota. Present at the hearing are the following people: Christine Pierce, the assistant county attorney; Rachel Mulsbury, the assistant county attorney; Alicia Sweep of County Health and Human Services; Dawn Weber, the lawyer for Nick; and John Mueller, no relation, the attorney for Kayla Rekieta; Carter Gerner, attorney at law, and for the children, and Christy Barber, guardian ad litem. So the children are represented by an attorney at this hearing, as well as a guardian ad litem. The difference, incidentally, between the child's attorney and a guardian ad litem is a guardian ad litem is supposed to look out for the best interests of the kids, whereas a child's attorney looks out for the best interests of the client. So it's the difference between a neutral person trying to determine what is in the best interest of the kids versus a person trying to advocate on behalf of a child for their desired outcome. So it's a presumptively neutral versus an advocate. And so that's the difference. So they have their own attorney, as well as an attorney presumptively appointed by the court for the purpose of advocating for the children, to the extent that they have a different interest from the parents or the government. They're a third party in the proceeding. So that is what's happening there. So they are represented, and that's cool. Okay. All right. All the parties appeared in person. At the beginning of the joint emergency protective hearing, the court met the requirements for a hearing procedure. Fine. Based on this, we have the children that are present, the 5 children. Venue is proper in this county because the kids reside in the county. Makes sense to me. The parentage: Kayla Rekieta is the mother of the minor children. Nicholas Rekieta is the father of the minor children. Mrs. Rekieta and Mr. Rekieta are married, and they share joint legal and physical custody. Cool. Petition: a CHIPS petition was filed. The alleged statutory grounds listed are incorporated by reference. Cool. Prima facie finding regarding it: the court previously found that the petition establishes a prima facie, which is just simply to say on its face. The document on its face, as in the same way as a complaint, in the same way as an indictment, in the same way as a search warrant, right? On the document's face, right, that it showed a juvenile protection matter exists and the children are subjects of the matter. So it was in proper form, and there's enough to warrant the court's review. Prima facie finding regarding endangerment. The court previously found the petition, again, just the allegation on its face, nothing more, establishes a prima facie showing on its face that the children's health, safety, or welfare would be immediately endangered if the children were regarded and care of parents. So I make a point of saying prima facie because it's just simply on the face of the thing. At this point, we're taking the government's word for it. That's prima facie, right? So we're just taking their word for it, and we say, okay, this is in good form. Just like we would take the government's word for it if it was a search warrant application, because the only people present in a search warrant application are the government. So in just the same way we would take their word for it if it were indictment or information, because the only people involved in that are the government. So in the same way, or for that matter, if it were not government and we were talking about some sort of TRO, which would be the generic equivalent in a civil proceeding, a temporary restraining order, right? A TRO, we would be taking the word of the filer in a civil lawsuit. So, just based on the document itself, does it make a case for some sort of extraordinary emergency action? Cool. All right. Service. The parents were served personally with the summons. Excellent. Motions to intervene. No motions to intervene. ICWA. The protections of the Indian Child Welfare Act do not apply in this case. The Indian Child Welfare Act is federal law. It is a very interesting law. It has very interesting implications. Long story short, it is very, very difficult to separate Native American children from their parents or their tribe. Okay, and the reasons for that have some historical context, because in the past, there were some unfortunate aspects when it came to Native American children. So the federal government passed a law that basically says you can't remove the children from the parents, and if you do, they have to be given over to the tribe first, and so forth and so on. And basically, only after you exhaust essentially every Native American resource can you look to non-Native American resources to take care of the kids. It has some pretty interesting coverage, but obviously these are not Native Americans, so the law does not apply. In case you care constitutionally, of course, the federal government has domain over this issue because it's tribes. And if you're concerned about equal protection, don't be, because the Constitution gives them authority to deal with the tribes, because it's in the Constitution, because reasons. So fine, no problem. All right, so we don't have to deal with ICWA, which is a whole universe of very weird, as is also just generally true of not Native American law in some senses, in a broader sense. So let's not go there. All right, we also have a specific law of the states called McKenna's law. The court provided the advice to 3 of the 5 children. I looked it up. All right, McKenna's law is a law that basically says in so many words, if a child is over the age of 10, they get a special advisement that they're entitled to an attorney, which if they can't afford one will be appointed by the court. They're entitled to a court-appointed attorney themselves, personally, to advocate for them personally if they're over the age of 10. And if they can't afford one will be appointed for them, which I think is kind of cool, incidentally. Because, the child might have an interest, which might conflict with one parent or the other, or the state, or all of them at the same time. The child might want different things, and they have a voice of their own. And they can only be asked to waive that after they've been provided an attorney in the first place. So they have to have an attorney meet with them in order to waive the right. So I think that's kind of cool. So I think that's fun. So fine, good times. All right, great. $10 from rogue count. A family court is long, painful, and expensive. Stay out if at all possible. Very much true. Family law was one subject I somewhat deliberately did not study. The only time I studied family law was for the bar because it was on the Virginia bar. Family law just makes me sad. It's a world of pain. I don't like it. It's also, in some senses, the least legally dependent area of law. Arguably, the field of law in which I practiced, or the field of law in which I operated for 15 years, patent law, is arguably the most legally, it's the least emotional, I think is probably the best way to put it, right? There's not a lot of emotions in patent law. So it might be the most legally versus factually driven field of law, possibly, of all of them. And if you had to pick the exact reverse of that, it would have to be family law, where the law seems to be the best interest of the child. What does that mean? Whatever we want to mean at the time seems to be functionally the right answer. So it is a not for me, because it is not law. It is facts and feelings, and that's not the realm in which I like to live. So I usually just take a pass on family law questions. So, fine. All right. Representation. The parties were advised of their right to be represented by counsel, and the parties were represented by counsel. Great. Ex parte hold. In order for the hearing, the children were placed on a law enforcement hold. The date of removal was May 23rd. The facts that warranted removal of the children on the ex parte, only one party, namely the government, only the government's involved, emergency order, essentially TRO, are as follows. On May 23, law enforcement officers from the Candido County Sheriff's Office executed a search warrant at the family residence. During the search, narcotics and drug paraphernalia were located. The parents were placed under arrest, and law enforcement officers placed the children on a law enforcement hold. Sounds logical to me. If for no other reason, the parents are under arrest, so obviously they can't watch the kids. So that makes logical sense. Continued hearing. An emergency protective care hearing was scheduled to be held on May 28th. At that time, the parents noticed to continue. The case has been continued for an additional, whatever that is, 8 days or something. So initially, the hearing was scheduled for 5 days later. So that's pretty fast. And then it's like, okay, we'd like an additional 6 days. And the court's like, cool, you can have more time. So they got an additional 6 days. So we are where we are, or whatever the math is on that. Don't ask me to do math. All right. Testimony. The court received testimony from Ashley Sweep, who is the CPS officer, Christy Barber, as well as someone who I assume is Nick's father, but I don't know for sure, but shares his name. All the witnesses were placed under oath. The court received the following exhibits. Exhibit 1, drug testing of the parents. Exhibit 2, drug testing of the children. Protective care determination. All parties and participants were offered the attorney to cross-examine the petitioner regarding the ex-parte filings. In other words, hey, you get to ask the government questions if you want. After receiving additional facts, the court determined protective care shall continue. So I've gone from, I suppose the equivalent would be a TRO, temporary restraining order, to a preliminary injunction, I guess, if we're going to try to analogize this to broader civil concepts, something like that. But in either case, we're moving forward on that for the moment while we figure out what else to do, which makes sense, right? We're going to try to figure it out as we go along, which is not atypical, kind of in any case or a civil case, and we'll revise as required. Fine. The court makes the following explicit and individual's findings in support of continued placement. So the court's going to make some findings of fact at this time on a preliminary posture, which, fine. All right. So the court thinks there's essentially like probable cause. As I try to analogize this to concepts you might be more familiar with, there's enough to make the suspicion work. All right. So Health and Human Services received a report involving Reketas on May the 23rd. That would be the cocaine found in the house. The report was I suppose cocaine is going to be found in the house at this point. The report was law enforcement was going to go to the home to execute a warrant. So Child Services receives a call, be like, hey, we're going to knock down the door. You have any interest in, that? So they're like, yeah, we have interest. Okay, upon executing the search warrant, law enforcement found presumptively 26 grams of cocaine, ketamine, drug paraphernalia, firearms, ammunition. We've discussed that at some length. Mrs. Sweep, the child services person, went to the home while the search was ongoing. So child services is there also as the police are knocking down the door. Cool. At the time, she learned the house was very cluttered. It was difficult to walk around the home without stepping on clothes, bedding, or blankets. The 4 of the 5 children were present. 1 child was not. Okay. All right. And then the most interesting part of this, which I've spent most of the day trying to figure out exactly what it means and coming up a little bit blank, but I'll share what I came up with. After being placed out of the home, the children were subject to a hair follicle drug testing. All the children except for 1 tested negative. The one who did not test negative tested positive for cocaine at a level of over 5,000 with a cutoff of 500. Okay, I have spent the better part of the day trying to figure out what this means practically and having a difficult time trying to figure out what it means practically. But here's what I came up with as best as I can determine. All right, so NewYorkDrugTesting.com has a helpful chart. And according to them, whoever they are, they're just a .com, so their feelings on the matter, at least as of 2006, when this chart was created for cocaine, and we're assuming, by the way, that 5,000 and 500 are measured in the same units as the chart, which, why not? But the court didn't tell us, so we'll just go with the presumption. The screening cutoff, which matches the 500, is 500 picograms per milligram. All right, so that's 500 trillionths of a gram per milligram. So, yeah, okay, so not very much. I mean, at least in terms of percentages. So 500 trillionths of a gram per milligram, which I suppose would be 500 billionths per gram, if you prefer. Okay. And then on their handy chart, they provide the following information, which I don't know where they're getting this from. I can't find their sources. It's a .com. I don't know who these guys are, but this is what they said in their infinite wisdom. They say that a range of 2,000 to 10,000 is indicative of medium use, which they say it means daily/weekends. So more than recreational, which would be low use, and more than high use, which would be constant. So we're in some sort of daily/weekends threshold. Okay, now I'm going to go on the working presumption that the 9-year-old, which is the one that testified, is not a daily/weekend user of cocaine. That seems like a reasonable presumption at this time. So I'm going to go on whatever it means. It probably does not mean that the 9-year-old is a daily/weekend user of cocaine. All right. So what can we sort of infer from this? All right. So the best I can determine from my limited Google Scholar searching on this issue, and it was difficult to find anything on this topic, but maybe I'm not searching right. But the only thing I could basically find is that it is that there is a possibility that this is accidental or cross-contaminant use. For example, by using a plate or spoon that had not been cleaned completely or cleaned fully properly, which, makes total logical sense because, again, we're talking about, trillionths of a gram per milligram or billionths of a gram per gram. So we're not necessarily talking about a whole lot here, right? It seems to me, based on what little I can determine. All right. Then also, it apparently does not seem to be possible, based on this alone, to be able to determine what it means in terms of the rate of use. So it also doesn't necessarily indicate by itself when the use occurred. So, it could be a very recent use comparatively versus a more distant use so it could be a more comparative, which would be, more potent or a lesser, or more distant, which would be lesser. It could be indicative of a one-time thing. It could be indicative of a longer-term exposure. It could be a lot of different things. So we don't have enough information on what it means in sort of a practical medical sense. But that's where I fell short in trying to determine what it means practically/medically. I can also tell you that this threshold of 500 is used by a lot of employers, and it's used by the government in certain contexts for pre-employment screenings, although sometimes they go for lesser thresholds for that. They go for 300 or even lesser amounts, depending on exactly what they're testing for. So, whatever. But it is indicative of cocaine exposure somehow, some way. Now, I will also take note here that they do not indicate whether a confirmation test was done and whether this is just a preliminary number. And again, based on my very limited Google foo, trying to figure out exactly what this means to this morning, there apparently are different procedures that are used after a preliminary test for the confirmatory test. So as best as I could determine, it could be the case that in a preliminary test, it's just the hair as is. But in a confirmation test, for example, the hair might be washed first, which, depending on the various scholars I attempted to read, may or may not be necessarily particularly effective, incidentally, at getting rid of cocaine that is merely on the hair as opposed to in it. But I digress. So it is not. It's also not clear what procedures were used exactly. So I'm not being given information, so I just have to highlight these things. I don't know because the government's not telling me. All they're telling me is it was 5,000 presumptively picograms per milliliter or picograms per milligram with a cutoff of 500 picograms per milligram. And they don't even really tell me that much. They don't even show their units. And they don't tell me if this is confirmed. So I'm a little bit frustrated by that. I'm a little bit annoyed. But the fact that it's only one child instead of all the children is more suggestive, at least to me, right? If I'm trying to think about what this means, right, it is more suggestive, at least to me, that one of the children came into accidental cross-contamination exposure that is not a frequent occurrence at the house. Because, well, if it were more frequent or more common, then presumptively more than one of the 5 kids would have it, right? I mean, that would be logical. So if only one of the 5 kids has it, then it presumably indicates that this is a accidental cross-contamination exposure that I assume, based on the fact that it's 1 out of 5, is only essentially a one-off, as opposed to being a more habitual thing, because again, if it were more habitual, you would expect it to hit more of the children, which it didn't. So it's more suggestive of a single exposure. At least that is the logic that I have applied to this. But I readily admit that I'm out of my depth on the practical implications of this. I am not a doctor. I don't have any particular education in drugs. I don't have any particular knowledge of this. I just did my best to try to read some academic articles to try to get a sense of what this was talking about so that I have some vague clue about what I'm talking about to try to reach some sort of conclusions that hopefully made some sort of sense. If I'm not using enough qualifications in this, you're not understanding what I'm trying to tell you. But that's what I got. All right. But either way, regardless of what it means practically, regardless of what it means medically, regardless of how much I should be concerned on that frame, regardless of all that, it's over 5,000. So it's 10 times the threshold, which is not exactly great. It's not exactly great. So, if it were like if it were closer to 500, then we'd be more in a position to play around with the margins. This is exactly what we did earlier when we were talking about the amount of cocaine that was found, right? We said, oh, it's 26 grams and change when we talked about the total amount of cocaine. But by the government's own documents, that included the packaging, right? So maybe we can dick around on the margins because we're kind of near the threshold. So maybe we can make this 26 grams more like 24 grams. And if we can make the 26 grams more like 24 grams, then hey, that's pretty good, because that would, by operation of law, reduce this from a 2nd degree charge to a 3rd degree charge, which is obviously preferable. But that we can only do that because we were playing on the margins, right? We're only doing that because we can play on the margins. But here, not so much with playing on the margins. This isn't 550. This is 5,000. So the sort of playing around on the margins idea doesn't exactly readily lend itself to these sets of facts, it seems to me. So I don't think that works. So short of somehow, some way, that the hair was unduly exposed to cocaine on that particular day, which I don't know even what that would be. He was putting powder in his hair for some reason, and it was cocaine powder. So, the child was putting cocaine powder in their hair by accident. So short of that, I don't know what scenario this would be that it wouldn't be concerning, because, it's 10 times the legal threshold, which seems to be a common threshold used by the government, as best as I can tell, for at least some purposes, and a common threshold that's used by employers for some purposes. So it's not, and I incidentally couldn't find any threshold more than 500. I found thresholds less than 500 for particular applications, for particular jobs in the government, for example. So I found cutoffs with less than 500, but I couldn't find, at least in my limited research, any cutoff of more than 500. So 500 seems to be the upper bound of where we start to care, and it's 10 times that number. And 10 times is a lot. So it is strongly suggestive that, there is cocaine in the house and there's been some sort of accidental cross-contamination exposure, perhaps by, using a spoon that had not been cleaned correctly. And once again, when I say not cleaned correctly, that doesn't necessarily mean not cleaned, because again, we're talking about, a very small amount, but I digress. Either way, it's not good news. It is not encouraging, and that is a problem. But, if there was not a confirmation test, perhaps there will be a confirmation test, and perhaps something lab. I don't know, because the government's not telling me, but it is not exactly great news. Pressing on. All right. Mr. Rekieta and Ms. Rekieta each submitted to a hair follicle drug test through Minnesota Monitoring. However, Health and Human Services has not received the results of those tests because subsequent to taking the test, the Rekietas revoked the release of information. Because the release of information, Health and Human Services has been unable to monitor the parents through additional drug testing. I don't necessarily have any objection to this. Obviously, it is in their interest to not have a confirmation test done of their hair if they can legally avoid it. So I do not object to this legally. I wouldn't give consent if I don't have to either. Why give the government a thing? I don't want to give the government a thing. Even if I didn't have cocaine in my hair, I still don't want to give the government a thing, because I don't want to play. I would, if I didn't have cocaine in my hair, I would get it done by an independent lab I trust, and perhaps sit on those results until a time that I felt was convenient through my attorney. So I don't necessarily object to this legally, but it is what it is. Pressing on. All right, Ms. Sweeps, who again is the Child Services representative here, went to the home on May the 28th. That would be 5 days later. She was allowed into the home, but not allowed access to the parents' bedroom. So Child Services comes and knocks on the doors, like, can I come in? Sure. And they say, can I go to the bedroom? No, you can't. And because she doesn't have a warrant, she can't look. So you could speculate, if you wish, about why they said no. But, that's what the facts are on that issue. So, fine. The guardian ad litem, who again is hypothetically a neutral attorney who represents the children represents the best interest of the child, and is an independent voice, at least hypothetically. And that's their job, is to be an independent voice for what they think is in the best interest of the children. So the guardian ad litem is in agreement. It's in the best interest of children to remain out of home placement at this time. Okay, fine. Surroundings or conditions. The children are in surroundings or conditions that endanger the health, safety, or welfare for the children's care and custody. Okay. Fair enough, given some of the descriptions we've heard of how the home was kept or not. Fair enough, I suppose. All right, contrary to welfare and best interest, children in the home. It's in the best interest of the child, which again, which when it comes to children is kind of the only legal standard that matters, which I personally find very frustrating because it's too nebulous for me. I like standards that are more easily able to be applied. And at least in my humble opinion, best interest of the child is not that. It seems too rampant to the whim of the person as opposed to being rooted in some sort of concrete principle, but perhaps that's just me. All right, so anyways, it's in the best interest of the child for the care, custody, and control of the children to remain with Health and Human Services, that is Child Services, for the purpose of placement with a suitable foster care provider. Continued custody of the children by the parents is contrary to the welfare of the children. The placement proposed by Child Services is in the best interests. This is the court saying this now. The court relies upon the best interest factors considered by child services as set forth in their petition, which were incorporated by reference. Fair enough. It is of the best interest of the children to be placed in foster care until the parents are able to provide a safe environment demonstrated through substantial compliance with case plan and by correcting the conditions which led of the out-of-house placement. So they're going to want to see some sort of behavior over some sort of course of time, which makes logical sense. The placement proposed by the agency is least restrictive and most home-like setting that meets the needs of the children. Okay. Reasonable efforts. Given the particular circumstances of the children and family at the time of the child removal, there were no services or efforts available that could have allowed the children to remain safely at home. Okay, fair enough. Child Services is providing reasonable efforts to reunify the children with their parents and to prevent the need for further out-of-house placement. However, those efforts have been hampered by the parents because the parents have revoked their consent to have their information shared relating to their drug testing with Child Services, have not been submitting to drug testing, and have not allowed Child Services full access to the home. I mean, reasonable from Child Services' point of view. All right, that seems, a bit problematic. The concern is the house is not being kept well. The concern is that the children have apparently had access or inadvertent access or cross-contamination access or some other inadvertent access to cocaine. And we'd like to, kind of prevent that from, whatever happening. Impulse gives $9.99 to say, I'm taking your kids to get past your constitutional right to have an attorney present. Well, it makes it easier to get to information. Officer said on tape on my case, I ended up winning. I respect that. And that can happen. So if that is the interest, if that's what's happening, then fair enough. All I can know right now is, of course, what the government is telling me on its own filings. Perhaps we'll learn more things that will change my opinion, as I've already learned more things that change my opinion, because that's how I roll. I try to make the best conclusions based on the limited information I have at the time. I've always tried to make the best conclusions I have based on the limited information I have at the time. As I gain more information, my opinion will change, because that's logical. $5 from Chase says, I thought the 9-year-old kid had 10 times the amount of coke. He did. We discussed it. It is not good news. It is not good news. So that is correct. It is 10 times the threshold for saying, yes, there's cocaine here. But what exactly that means in terms of exposure, method of exposure, time frame of exposure, and all the rest is not immediately apparent based on my very limited research on the issue. $2 from Nice Podcast. Stupid says, Bratty Kids needs to stop raiding Dad's Coke stash. I presume the 9-year-old is not raiding Dad's Coke stash. I'm going to go on the presumption that is not what is happening in this particular case, but thank you very much for your super chat. All right, let's see. How do I see super chats? I don't know. I know there's a way to do it, but I don't know how. Lame. All right, let's press on. Hair tests are pretty accurate. They can be, but as we've discussed, we don't know if there's a confirmation test done, and we don't know what other so we don't have enough information at this time because the government hasn't told me, and so I don't know. I can only sort of operate on what I know as we do. But yes, hair tests are accurate if all the procedures are followed and confirmatory tests and so forth and so on. That is true. But even if the test is accurate, it still doesn't tell you what that means in terms of the method of exposure. It still doesn't tell you the time frame of exposure and so forth and so on. So it doesn't give you all the information. All it really says is that this person has been exposed to cocaine. And the method of exposure, the intentionality of exposure, the time frame of exposure is not readily apparent from those numbers. So, whatever. Why am I so defensive of a parent whose 9-year-old tested positive for cocaine? I don't know that I'm unduly defensive. I don't think that's a fair characterization. I'm just trying to operate based on what I do know and what I don't know. and I'm just trying to expose things that the government has not told me. I'm showing my work as I go along, by the way. So I'm showing my work. It's like, okay, here's what they told me. Here's what they didn't tell me. And then based on my limited research that I did, here's what I was able to discover. And here's what I think is true. So I don't think I'm being unduly defensive. I'm just trying to show you what I think and showing my work as I go along. I was quite clear the amount is concerning. I was quite clear that the amount, short of, insert somewhat strange hypothetical X, is strongly suggestive that there has been exposure to cocaine. So I don't think I've been unduly defensive. I don't think it's a fair characterization. Kylie needs a holiday for Australian $7.99. Are all 5 children currently in care? Yes. Also, there's an update on whether he's still trying to represent the girlfriend and wife. He is not. We know that for a fact because the attorney's names were on the front page. Thank you for help. And the girlfriend at the moment does not seem to be represented because charges have been dropped, which is also makes sense given what we know. You can't get that level of accidental exposure on a spoon? Well, I don't know that. And I don't know that. So I don't know. And I don't know how you know that. So I don't know. So I'm just highlighting possibilities. It's like I told you I am not an expert in this domain. I made that quite clear repeatedly. I am not an expert in this domain. I made quite clear that I am operating a bit out of my depth. I made quite clear I did my best to do some Google foo and try to do some research to try to find out what these things mean, and had a bit of a frustrating time doing so. And I'm just trying to do my best analyzing possibilities. I'm not sure what more you can ask from me. Please be gracious to me. I'm doing my best. $5 from Snazzy Trinkets Jewelry. Could this positive result be from some prescription drug? I don't think so, no, because presumably any prescription drug they would be taking, if it for example for ADHD, which would be some sort of amphetamine derivative, which would have a different testing. So no, I don't think that's possible. No, I don't think it could be from a prescription, because I don't think there's any prescription that could test positive for cocaine. Give me the live information I have. $5 from testing 2741. I lull at libertarians and conservatives that subtly 100% trust the government when the government targets someone they dislike. I don't trust the government necessarily. I'm operating based on what I know. God damn it. I'm operating based on what I know. It's like all I know is what I'm reading. This is the extent of my information. I'm trying to do my best to give you the best opinion I can based on the limited information I have available to me. As I learn more, hopefully my opinion will become refined and deeper, which is all you can really expect from anybody. I'm doing my best. What you read said 5,000 was regular use. That is correct. Well, more to the point, well, yes. What I read said 5,000 would be indicative. They said 2,000 to 10,000 would be indicative of daily/weekend use. You are correct. I am assuming that is not the case here. You are absolutely correct. The thing I read from New York drug testing, which incidentally did not show its work and did not show where they were getting these things from. So I don't know if they made it up. I don't know where they're getting it from. But yes, they said that 2,000 to 10,000 would be indicative of daily/weekend use. I'm assuming that's not the case here. I'm assuming it because it is a 9-year-old. That is the extent of the basis of my reasoning. Thank you for playing at this time. Probably not a 9-year-old daily cocaine user. I'm just guessing. Just guessing that's not what's happening in this case. Okay. Anyways, we're moving back to the story. The children were removed from the home on May 23rd, which is 14 days in out-of-home placement. The permanency progress review hearing must be held no later than 180 days. If applicable, the permanency petition must be filed no later than 335 days. If applicable, an admit-deny hearing to determine permit status shall be held on May 23, 2025, pursuant to law. So if they're going to try to make this permanent, which I assume they're not going to, they have to start that process 180 days in with the petition filed 335 days with a hearing at least on May of next year. But I assume that's not going to happen, but we'll see. An admit-deny hearing was held on June the 6th. The parents were each represented by an attorney. The parents were advised of their right to have trial regarding the petition, including the right to testify or question and call witnesses at trial to require the petitioner prove by clear and convincing evidence, which is the standard in child removal proceedings. Clear and convincing evidence is the correct standard, is the medium standard in law for final determination, right? In a typical civil proceeding, the standard is preponderance of the evidence, which means more likely than not, which means just over 50%. Anything over 50% will be fine. That is preponderance of the evidence. Beyond a reasonable doubt is what we use in criminal law. Depending on who you ask, attorneys will put different numbers on it. I think 95% plus is a pretty reasonable number to put on it. So it's something in that ballpark. Clear and convincing evidence is somewhere in between. What is clear and convincing evidence? I don't know. 2/3, 70%, 3/4, something like that. So that's the level of confidence we need. That is the correct standard in a child removal proceeding. So that's what we have to find. You're talking about the chat, loving the government, not you? Fair enough. Yes. I also, incidentally, although the comment has been deleted, I did find this particularly rich. All right. On one of my recent workouts, I think it was the one before this one. All right. So on one of my workouts, the one before this one, there was a commenter who has since deleted it saying, you know, Kurt, I used to love you, but you've turned into the conservative legal eagle. You are nothing but a bootlicker for the police and the prosecution. And I was like, have you seen any of my recent videos about the Karen Reed trial? Because I'm not sure how much of a bootlicker I am. I mean, damn. You know? And then he deleted his comment, presumably realizing he was an idiot. All right. It is in the best interest of the child. They shall remain in protective care of child services for the person's placement with an appropriate licensed foster care provider. All right. I am interpreting that to mean the children are not presently in the custody of the relatives. I don't know that for a fact, but that would be a logical conclusion. Because if they're in the custody of child services and the court says put them with an appropriate licensed care provider, I'm going to go on the presumption that the relatives of Nick and Kayla are not, just happen to be licensed providers. That isn't necessarily to say they can't become licensed providers, but I'm assuming that, on the date of removal, they were not licensed providers because, why would they be? So I don't know what the process to become a licensed provider is, but I assume it has something to do with the government taking a look up your ass. If I had to guess, which of course I do, that it has the government looking up your ass and making sure that you meet all their happy criteria. So I'm going to go on the presumption for the moment the children are not with the parents, with the grandparents, I should say, and they are currently with foster care somewhere, quite probably not all together, if I had to guess. But I'm just guessing. But that seems possible. So not great. Foster care parents have a lower standard than parents. First of all, I'm not sure that's 100% true. Second of all, even if it is, it still means the government looking up your ass. Maybe less. I don't know. But that's where we are. Reasonable efforts. Child Services providing reasonable efforts to reunify the children. However, those efforts have been hampered by the parents because they've revoked their consent to share the information with the government, have not been submitting to drug testing, and have not allowed Child Services full access, and the Indian Child Welfare Act does not apply, which is probably a good thing because it's a pain in the ass. All right, so here is the order of the court for the moment. The children shall remain in the protective care of child services for the purpose of placement with an appropriate licensed foster care provider, which I'm assuming is not the grandparents, and therefore is some random people. And I'm also assuming the children have been broken up because, probably can't find someone who takes all 5 children in, if I had to guess, which is not great. Services. The following shall be provided to children and the children's family. All right. The parents shall submit to a chemical use assessment and shall follow all recommendations. So the court is ordering a drug test for the purposes of child services and the child care of the custody, which, yeah. So I assume if I were a betting man, I assume they're going to try to fight that order. So I would assume to see some sort of filing from their attorneys, or not, necessarily see it, because again, this thing isn't even supposed to be private, and this thing isn't even supposed to be public in the first place. But their attorneys could try to fight it, and I would, obviously, for their criminal exposure. But the families are like, the court is like, well, I want it. And even if the attorneys for Nick and Kayla are able to get the order withdrawn, I don't think that they're going to get their children back until the court is satisfied. And without that information, that would be presumptively much harder. So that's where that's at. So not great. All right. Let's see. The parents shall abstain from use and possession of all mood-altering substances except as provided by as prescribed, which presumably includes alcohol, because that's a mood-altering substance now, isn't it? So they may not be under probation, but they're now under order of the child court to not consume anything if they are. So there's that. The parents shall submit to chemical testing of any type at the request of child services and or the guardian ad litem. So there's that. The parents shall sign all necessary releases, so service providers may share the information with child services and the guardian ad litem. So you have to waive your medical privacy. Cool. The parents shall sign releases to the guardian ad litem and child services from MMI, so they monitor and verify the drug testing results. So it looks like drug testing / alcohol monitoring will be in their future. Again, they may be able to fight it. They may be able to fight against it. But even if they're successful in that effort, I assume that without doing that, the court will be somewhat disinclined to reunite the kids with their parents. So that's that. So they'll have to. So maybe they don't care, because maybe at this point they would pop clean. I have no idea, but maybe they don't want to comply with that, and maybe there's an interest of their criminal case versus their kids, and maybe there's a conflict there. Can't speak to that, but I'm assuming their attorney is advising them on those issues accordingly. I know, Kestrel, there's a chance the grandparents are foster parents. I know there's a chance. I explained my reasoning. I showed my work. I explained my reasoning and I showed my work. Why are you saying that, Kestrel? I said, look, the order says licensed foster care. I was like, well, it's probably pretty reasonable to assume they're not licensed on the date of the incident. I mean, because why would they be? And it's also reasonable to assume that if they are to be licensed, it would require the government looking up their ass. And, that probably hasn't happened yet, because that would be kind of fast. And child services tends to be somewhat, whatever. But I showed my work. I showed my work, man. Why do you mean? All right. Child services shall file an out-of-placement plan and provide it to the parties in foster care within 30 days of the court order, placing the children in foster care, an order for protective care, an order transferring legal custody to child services, whichever is earliest. Okay. The out-of-home placement shall be filed no later than June 22nd, 2022. Okay. The terms of parental and sibling visitation pending further proceedings are: parents' visitation between the parents and the children shall be supervised at supervised safety center or supervised building by a member of the staff. So even assuming somehow the children are in the custody of their grandparents, if the parents want to visit them, it has to be in the government's building. So there's that. It can be done in hours. Okay, maybe it can. I don't know. I'm not an expert. Didn't I tell you pretty clearly that family law is not my bag, and it's something I somewhat deliberately did not study in law school because I don't like it and it makes me sad. I don't know what more I can be doing. I honest to God don't know what more I can be doing to highlight when I do know things and I don't know things. I made it quite clear that I don't understand what the 505,000 mean. I did my best. I made it quite clear family law is not my bag. It is something I deliberately did not study. So I'm just doing my best. Why do you hate me? I'm doing my best. I'm showing my work. Relative search. Child Services shall exercise due diligence to identify and notify adult relatives within 30 days. The agency shall continue to appropriately involve relatives who've responded. The parents shall cooperate in providing information to identify relatives. Not later than 90 days, the agency shall report to the court and efforts and decisions regarding placement pursuant to law, which presumably in this case means with some sort of relative. So I don't know what that means, but apparently that's something they're supposed to be doing. This order shall be shared with providers of service under the care plan, and such providers are authorized to share information with each other as necessary. So all of them can share information with each other, and that's fine. Child Services is authorized as follows: to arrange for major medical care and surgery for the children in a life-threatening situation. Not clear necessarily what Child Services and or the state of Minnesota considers life-saving or life-threatening, but we will digress for the moment. To arrange for routine medical care and dental care, including necessary immunization and vaccination. To obtain the children's educational, medical, dental, psychological, psychiatric, and dental records, including mental health and chemical dependency records, if any, for the purpose of meeting their needs. So they get access to all the medical records because, well, they're the parents now. De facto. To approve, and I suppose de jure to some degree, to approve educational or mental health services for the children as needed. Pursuant to relative law, Child Services is specifically authorized to have access to the following data on the children: any medical data, correction and detention data, juvenile court data, court status data, and any health records relevant to law. Again, they are the parents, so they're the guardians, and so they're getting access to the information the guardians would get access to, which kind of makes sense. So, fair. Providers of services, including educational, medical, and mental health, are authorized to receive information regarding the children or release information to Child Services. So all those people have permission from the court to release information because, again, those are the parents for the moment. This order shall be shared with providers of service made under the plan, and such providers are authorized to share information with each other as necessary to carry out the intent and purpose of the plan. Pursuant to Rule 6 of the Juvenile Rules, this order establishes the following deadlines. Discovery. The deadline for discovery is July 15th. This includes the following: inspection and copying of documents or other tangible evidence, for example, the lab data, I assume. Identification, name, and persons of all persons intended to be called as witnesses, and shall allow all parties to inspect and copy such written or recorded statements within the parties' knowledge relating to the case. Again, lab data, including the lab technician who did it, presumably. Identifying the names and addresses of all persons intended to be called as an expert witness. The subject matter about which each expert is expected to testify, and the summary of grounds for each opinion. The following additional pretrial preparation and discovery is authorized: and the reports from such discovery shall be complete and disclosed. Physical examination and psychological examinations, including depositions. All purported exhibits must be uploaded to the Minnesota Digital Exhibit System no later than July 15th. Information on how to use that can be found at the court site. All pretrial motions must be filed by July 15th. Pretrial conference. A pretrial conference shall be held on July 15th at 3 p.m. Their parties and legal counsel shall come to the conference prepared to discuss whether settlement of any all issues is possible and discuss issues set forth. So that makes sense. And that's July 15th, so that's a pretty reasonably quick date. So that's cool. Trial, if we're going to go down that way. Trial in this matter shall begin July 23rd, July 24th, July 25th, and July 26th, if we're going to go that way. As it relates to, the temporary status, because remember, the permanent petition isn't due till later. So if you want to have a trial on the temporary order, you are entitled to that. And then if they file for permanent removal proceedings, that would be at a later time, which we already discussed in the document. The court will try to notify the parents of the priority status 1 week before trial. The trial shall not be continued or adjourned for more than 1 week unless the court finds the continuance or adjournment is in the best interest of the children. The trial shall continue until complete. So once it's started, we're not going to stop unless we have to. The trial shall be conducted pursuant to relevant law as it relates to this kind of proceeding. The parties shall participate in a court settlement conference or alternative dispute resolution. Cool. That's fine. All hearings to take place in the Candido High County Courthouse because where else would it be? This order is subject to revision, as you would expect, and all previous orders of the court remain in effect unless explicitly amended, hence the new judge, Keith, who is our new judge. So, yeah, that's all fine. So that all seems somewhat standard and not troubling, except, of course, for the drug amount. Why do we think they're refusing testing? Because the court just told me they are. Well, Child Services told the court that they are, and I have no basis to assume they're lying. And also, they withdrew their consent, and I have no basis to believe they're lying. So, that would be why. I have no basis at this time to believe they're lying, and it's prima facie. So, until I hear differently, it's like, well, okay, fine. I'm going to accept this information and move on. Until I have a reason to not accept the information, and then I'll tell you accordingly. I changed my opinion with new information. It's amazing. Colonies of Holiday says, you're doing amazing, Kurt, in being neutral with your opinion regarding the law. Was a supervised contact worker for years, and it's a maze. Yeah, I believe that. I believe it's a maze for sure. So that's what's happening. So Nick doesn't seem interested in showing good effort to CPS. At least not at this time, no. And I don't necessarily have an objection to that in principle. Because, well, from a legal perspective, I don't have an objection to it in principle. Because, of course, his children are unfortunately not the only thing that is a consideration in this equation. He also has to be concerned about giving information to the government relating to his criminal trial, which, of course, I'd want to avoid if I possibly could. I mean, as far as that goes, right? If my only consideration was the criminal trial, then, you're the government, you prove it, and I'm keeping my mouth shut, and I'm not giving you jack shit, would be roughly my attitude. But, now there's a counter consideration as it relates to his children. And at least in the immediate of this hearing, I sort of understand, at least in principle, why the balance was cast the way they did. Because I presume his attorneys were trying to preserve his options as long as they could. Plus, there might be factual reasons that they were trying to avoid it. For example, that they would pop positive, which obviously would not be helpful in their criminal case. So there's that. So there's considerations at work. And trying to figure out how to balance all those things is challenging. I'm not stopping with false positives. No, I tend to agree with you that it's unlikely to be a false positive. I think that's an unlikely outcome, and I hope I indicated as much. I simply noted that there was no confirmation test. I simply noted that there was none indicated. And I simply noted that there's reasons. Presumably, we do confirmation tests. I mean, that those are typically done for some reason, and there's none indicated. And I don't know the methodology exactly of the test, and I don't know who did it or when or how, and blah 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 blah. But yes, I agree with you. It's 10 times the threshold, so we're not dicking around on the margins. We're not trying to make 550 disappear to less than 500. We're not trying to make 550 become 490. We're trying to make 5,000 become 490. That's obviously a much harder prospect. So, yes, I tend to agree with you that it is very negative legal news. $2 from Linda Richards says, thanks for even keel. I always do my best. I always do my best to give you the best legal analysis I can, regardless of the situation, based on the facts that I understand, and go from there. So thank you very much for your kind chat. And apparently 5,000 for whatever reason is where they stop, because it said in excess of 5,000. So I'm assuming, but I don't know, but I'm assuming for whatever reason they stopped testing or they stopped counting at 5,000. I don't know why that would be, but that would be logical because they said over 5,000. And they didn't say so do they stop counting at 5,000? And if so, why? I'd want to know. Orville 999 says, how well networked and coordinated are all you and law tubers? Do you circle the wagons for each other? Is it more like a bunch of strangers? That's a difficult question to answer in a global sense. What I would say is that, as you would kind of expect, everyone's relationships with other law tubers is different because it's kind of like any friend group, right? It's like asking me, it's a little bit like asking me it would be like a little bit like asking me what is the relationship for each person in a friend group to everyone else. And that's difficult to answer at best because, different people are going to have different relationships. So it's a difficult question to answer. The people I'm going to be closest to are not going to be the people that another law tuber are closest to, or the people they're most friendly to, or the people they feel like they get along with the best, and so forth and so on. So there's that. In answer to your other half of your question, LawTube has always been an amorphous group at best. The closest we came to something that could resemble a cooperative relationship was during the Kyle Rittenhouse trial. And that ended not later than the Johnny Depp trial for any number of reasons. But the relationship these days is much more analogous to independent sovereign nation states that from time to time work with each other and have varying relationships with each other rather than a confederation. So, but even at its peak, LawTube was never really a formal thing. It's just that it was always an amorphous thing that at best had a closer pragmatic relationship at the time to some degree. So that's the best answer I can give to that, and hopefully that answers your question. $5 from RL7247 says, wow, just thinking, I appreciate your coverage. Many tubers won't touch subjects to do with fellow law tuber acquaintances. Well, I want to give you the best legal analysis I possibly can. And, Nick has problems. Nick has problems on his criminal case. Now it's very likely he will not see any prison or jail because we discussed that. Remember, we discussed that from the sentencing tables, based on the charges as they currently exist, which again could be subject to change, but based on the charges as they currently exist for this particular offense with a criminal history score of 0. And yes, I understand that he has some technical misdemeanors on driving, but I'm assuming that those don't count for the purposes of this calculation. But with this particular offense with a criminal history score of 0, the presumptive sentence, according to Minnesota guidelines, is 48 months, all suspended. And even if he had a criminal history score of 1, it would be It would still be all suspended. It would just be a longer number. I forget what it is. It's like 58 or something. I don't remember. It doesn't matter. But even if he had a criminal history score of 1, it would still be all presumptively suspended. So the most plausible outcome. So even if he's convicted of everything that's currently on the board, he would not serve jail time. Is the most plausible outcome. Technically the judge is allowed to sentence him to up to a year in jail, but I'm assuming that won't happen. And I'm also assuming that, based on the fact that he's led a reasonably law-abiding life up to this point, for example, I'm assuming that if there were jail time, it would be fairly de minimis by comparison. It might be even something like show up on the weekends for some X period of time. It might be something like that. But I'm not assuming that it's going to be, so either it's going to be 0 or a much smaller number. So yes, I understand hypothetically 25 years the max, but not so much because, well, as I just said, he has a criminal history score of 0 and the sentencing table says 48 suspended. So, there's that. Now, that being the case, however, it's possible the charges will change because the lab will test the drugs and other things will change and there might be other charges that might change that calculation in the future. But sitting where we are right now, that's where we're at. So I try to give you the best possible outcome. All right. Now, this is an interesting comment because I actually looked this up and I was able to get this concluded. If they're smoking with children in the house or next to him, it could appear in hair follicles without being in someone's system, especially longer hair. All right. I did find this in the academic literature. I found this in the academic literature, and they've tested this. Apparently, somehow, some way, under some sort of controlled environment, they got a bunch of people to smoke cocaine in a room with people who didn't smoke cocaine there for an hour and then tested their hair. And those people popped at something, I'm going to misquote the number, but something like 20 instead of like 500. So yes, you can get cocaine in your hair from smoke, but not at these numbers. So I don't think that is the most plausible thing, but thank you anyway. Where'd he buy the gun? Well, he kept it under the bed with loose ammo. I mean, I don't know that the gun was necessarily not in a trigger lock, so I couldn't speak to that. Where did he buy the gun? I assume he bought it legally through an FFL. I mean, because why not? Yeah, I don't really feel like this is a fair comment either, to be honest. Sky Queen, I don't really feel like this is a fair comment. That Kurt would put down his broom. I just don't feel like that's a fair comment. My immediate reaction was my immediate reaction, and based on who at least I thought I knew, Nick, and based perhaps on my own naivety about what drug use looks like, and so I didn't recognize what I was seeing on camera. And I've discussed this already at some length. But I just don't feel like that's a fair characterization. I reacted the way I reacted because, well, my friend was being accused and my friend was in trouble, and my immediate reaction was to want to defend my friend, which I think is a pretty understandable immediate reaction. It's like, your friend is in trouble and your immediate reaction is, defend my friend. So I don't think that that's a fair characterization. And as I've learned more information, I've changed my analysis accordingly. Once, for example, it was explained to me, for example, in the search warrant, what the police saw, and I was like, oh yeah, that makes sense. I didn't see it. I couldn't see it. But as soon as it was explained to me, I'm like, oh yeah, that makes sense. So I don't think that's a fair characterization. I think I've always tried to analyze things under the best analysis I can. And if for some reason, for some reason the argument changes in Nick's favor, I'll give you that opinion too, because that would be a reasonable thing to do. So I just don't feel like that's a fair characterization. Russell Town says, reasonable analysis and explanation. Thank you very much. Do you think part of the reluctance to give information CPS is the information getting leaked? Yeah, I think so. Could it be ADHD for a child? I don't think so. I don't think any ADHD medication would test positive for the cocaine, things they're looking for. I don't think that's likely. If Nick and Kayla won't get tested, they might be denied visitation. Possible, I suppose. 1499 says, you're doing an amazing job being neutral. Thank you. I read that before. I appreciate it. What's the emergency protective order bit? The emergency protective order is Nick can't be with his kids for the immediate future, is the emergency order. If this is all Vosh or Destiny, you'd all be ripping them relentlessly. That's possible, but we got to sweep it up for Nick. Yes, that's quite possible. But then in that situation, I'm not friends with the people. And so my analysis would be more objective. And even in my very first video, I could not have been clearer if I tried. I said repeatedly that our feelings may not be correct. I said repeatedly, they might not be the right feelings. I recognized as it was happening that I had feelings for my friend that were influencing my judgment, and I told you that. Clearly, unmistakably, that I was having feelings and they could be the wrong feelings. Could not have been clearer if I tried. Because my feeling was defend my friend. I am not friends with Vosh or Destiny at this time. So you're correct. I would not be influenced by my friendship with them because I don't have it. But I told you. I showed my work. I feel like this is unfair. I showed my work. I feel like this is unfair. Ritalin causes cocaine false positives? That doesn't seem very likely to me. I mean, Ritalin is amphetamine. So I don't think amphetamine would test positive and cocaine would test positive. That doesn't sound likely to me. So I would not presume that to be true. So I don't think that's I don't know. Do the grandparents want the 5 kids? I mean, I presume so. My chat keeps like resetting, so I'm having trouble seeing where I'm at. In case you're wondering why I'm scrolling and repeating chats, because for some reason it's acting weird on me, on my side. But that's okay, we'll make it through. Google is loaded with data and explanations for false positives. Go look. I tried. I did my best in the academic research. I was looking principally on Google Scholar because I was looking for, something that had some sort of scholarship behind it so it wouldn't be bullshit. But I tried. I could not find anything, at least in the searching that I did today. I am not beyond the possibility of a false positive, but then hair testing is generally seen as fairly reliable. So I somewhat discount that possibility at this time. I don't believe this crap. Kurt, you should check yourself for spreading this crap. I mean, I believe it on a prima facie. It's I believe it on a prima facie. I have no particular reason to immediately disbelieve it, and it's consistent with other things the government has presented at this time. So I have no particular reason to disbelieve it at this time. I mean, I'm waiting, of course, for a counter response, but it seems like superficially valid. So I'm going to go with that until, there's an argument to the contrary, and then we'll go evaluate that, I suppose. Assuming the lab technician didn't fake the tests, that's possible, of course. That has been occasionally known to occur. You're not completely invalid for saying that possibility, but hopefully that's not the situation here. But of course, you have to prove that. You have to prove that. So that's challenging at best. If the chat would stop resetting for me so that I could read it, that'd be great. Will the weight of the cocaine containers be subtracted from the total weight? I presume that's a valid argument. I don't know the finer points of Minnesota law, but I assume that's a valid argument. And we only have to get rid of 1.5 grams, which, a gram is a paperclip. So you're not asking for much to get rid of 1.5 grams. You have to get rid of a paperclip. So I'm assuming that's possible. I mean, we're on the margin. So I'm assuming that's possible. When we're talking about 26 grams versus 25. 25 is the threshold. So we have to get rid of 1.5 grams. It's like, okay, I assume that's possible. In this test, we're talking about 5,000 versus 500. It's like, yeah, we're not playing on the margins anymore. That strikes me as not so possible. It might have been crack, not cocaine. I don't remember. I'll get back to you on that issue. Almost 140,000. Thank you. Yeah, things have been good for me recently on the channel. I'm at 139. I binged since we've been talking. I think. I think we binged since I've been talking, or at least I just noticed it. Yeah, we're at 139,000 now. Cool. We passed another 1,000 threshold. Excellent. If you haven't seen my Karen Reed videos, I think they've been very good, personally. I know it might be might be slightly cringe to praise your own content, but I've been pretty pleased with some of the work that we've been doing recently, so I hope you really enjoy it. Yeah. 6.99 from Dominique. I'm sorry, by the way, if I'm missing some of your super chats. It's just YouTube is, at least the browser I'm using is having problems right now. Dominique Fortin says, thank you for mostly unbiased and rational analysis, which is understandable because you're just a subject. I do my best. I do my best. And when I can't, I tell you. It's like I always try to show my work. If I don't know something, I tell you. It's like, look, I don't know much about drugs. I don't really understand completely what these numbers mean. Here's the best I was able to determine. Here's some possibilities that I can see. It's like family law is not my thing, but I'm doing my best. It's like, I always try to show my work, explain things. I always try to show you where I'm weak on law, on fact. It's like I never want to front. I do my best. And I tell you the best I can when I don't know something or I'm ignorant or I don't understand something. I always want to try to act from a place of knowledge and give you the best I can. You're right. Sorry, I misspoke. You're correct. I apologize. Ritalin's methamphetamine. You're correct. I was thinking of Adderall. I apologize. My mistake. You're absolutely correct. Thank you for the correction. My bad. See, see what happened just there? I made a mistake and I admitted it. Yeah. Who knew, right? Enchiladas unbreaded. Enchiladas unbreaded. Now I want enchiladas, and that's not fair. Says you're doing well with what the work is doing well with what you have to work with. Reasonable. Thank you. It's very kind of you. Yeah. This incidentally, for example, was why I didn't really think that some of the channels, which were so I didn't. This is part of the reason why, incidentally, I didn't think that some of the channels which were so strong in critiquing me and or critiquing my character relative to the first video I didn't really feel they were being very fair, because it's like I went out of my way repeatedly to say, I don't know that what I'm feeling are the right feelings are correct. I don't know they're correct. I'm not trying to make a moral stance that these are the feelings. It's just what I'm feeling. And I feel confused. And it's like, I just don't think that's fair. I just don't know how you can say that someone has bad character when they themselves are telling you, I have doubts that my reaction is the correct reaction. I have doubts that my feelings are the correct feelings. I have doubts. It's like, how much more honesty can you get from somebody than that? It's like, this is a person of bad character, someone who's willing to admit, I don't know what I'm feeling is correct. This is bad character. Someone's like, I'm not trying to make a moral claim. I'm just saying how I feel in the moment. And saying that and being honest about it is a representation of bad character. And some of the people that were making videos about me seem to be very, very willing to ignore the fact that I said, I don't know what I'm feeling is correct, and seem very willing to be somewhat uncharitable to me in my, let's call it, grief in the moment. But, I digress. This stream is monetized. Well, they're all monetized. There's no reason to demonetize it. What's your point? All right. I'm tired of chat just being like annoying. All right. I'm going to go back to YouTube's back end and answer the super chats I missed along the way. And then I'm probably going to end the stream. So give me a second to do that, and then we'll land this plane. Unless you guys want to super chat more, then I guess we can hang out more. But I just don't really have much more to say at this time on this particular issue. HIPAA? No, and you know better than that. Please tell me you're not really being serious. Please tell me you're not being serious. Whoever in chat said HIPAA. Please tell me that was a joke. No. No. Let me go back up to the top of the super chats and read them all, just to make sure I didn't miss any. Coughing Bird became an uncivilian. Thank you for hitting the join button. Kelly C became an uncivilian. Thank you for hitting the join button. Rogue Accountant gave $10 to say family court is long, painful, and expensive for everyone. Stay out of it all possible, fellow uncivilians. Preach. Veronica has been a member for 16 months. Coughing Bird gifted 10 gift memberships. Thank you. Kyrie Eelson gifted 10 gift memberships. Thank you. Bella Stella gifted 10 gift memberships. Nice podcast, stupid. $2 said bratty kid needs to stop reading kids' dad's coke stash. At least it's funnier the second time. Chase, $5 said, I thought the 9-year-old kid had 10 times the testable amount of coke. He did. You're correct. PJ Wolf Wilmers has been a member for 5 months. Haley Mouse has been a member for 18 months. Morris has been a member for 24 months. AJ Red Sox has been a member for 12 months. Impulse01 said, I'm taking your kids, in quotes, I'm taking your kids to get past your constitutional right to have an attorney present. We find it makes it easier to get information, on quote. Officer said on tape, in my case, I ended up winning. Yeah, that makes sense. New York Renal MD, this level can only be explained daily use. Topical contamination cannot explain this. Oh, this is a guy with an MD, so I'm inclined to believe you, New York Renal MD. So I'll come to you for my medical information so you can educate me medically, because I am out of my depth, as I imagined. Thank you. So New York Renal MD says this level can only be explained daily use. Topical contamination cannot explain this. Light use is 300 and 3,000. Moderate use 3,000 to 10,000. I have a really difficult time, New York Renal MD, believing that the 9-year-old is a daily user of cocaine. I appreciate that you have an MD and you know way, way more than what I'm talking about. But I don't think it's too much to want to look for alternative explanations other than the 9-year-old is a daily cocaine user. That strikes me as a very odd conclusion to draw. So I appreciate that, but I'm looking for realistic alternative possibilities. And if you're going to tell me that there are no realistic alternative possibilities, I'm going to become incredibly depressed. If the only plausible explanation is the 9-year-old is a daily cocaine user, we are in a completely different universe than when we started this stream. I really hope that's not what you're saying. I really hope that's not what you're saying. Yeah. Kylie needs a something. Are all 5 kids currently in care? Yes. Also, there's an update of whether he's still trying to represent. They're not. The child needs to be examined medically for child abuse. I have no objection to that. And the court seems to have just ordered it, so I have no objection to that. Snazzy Trinket says, could this positive result be from some prescription? I don't think that's possible, given what limited I know. What is LawTube? LawTube is a name for a group of attorneys that produce similar content. Good Logic has said that LawTube is a genre, which I think is a fair description. I would describe LawTube as the group of attorneys who have appeared on each other's channels and have collaborated with each other on a somewhat frequent basis, is how I would describe it. It's the pool of people that have worked with, streamed with each other, and cooperated and collaborated with each other over time. That's how I would describe LawTube personally, but whatever. So, for example, I would not personally describe Legal Eagle as being LawTube because he doesn't run in our circles. And Steve Leto, for example, I would not describe as being LawTube because he doesn't run in our circles. But that's me. Testing 2741, but I'm sure other people would have other definitions, but you asked for mine. Testing 2741 says, I lolled at libertarians and conservatives that subtly trust 100% the government when the government targets someone they dislike. Really now says, you're going to need to elaborate how clear you were. Didn't understand you. Some people apparently didn't, man. That's my point. Some people apparently didn't understand me the first time. Testing 2741 says, not talking, but you, Uncivil. Appreciate. Emma Daisy says, too much of an anomaly. No other kids were positive. Need a second test. There's nothing to freak out over until a second test is positive. I appreciate that answer. That's something. Quinn said 499 says, I don't think you're being unfair or defending him. You're doing a good job. Thank you. Arla for 7247 for 5 Canadian says, don't care who the parent is. This will have a negative effect on kids. I mean, that's true. Even if every allegation of this is true, the very fact it's happening will have some impact on the kids. And that is regrettable unto itself. Who cares about the amount of cocaine on kids? It should be 0. Well, I only care for pragmatic reasons. I only care for what it indicates pragmatically. And, or how concerned I should be from a medical perspective, for example. Because I understand that's a legal threshold. I just don't know what it means pragmatically. And I'd like to know what it means pragmatically, because that would help inform how concerned I should be about it. So that's why I care. I'm not saying any amount of cocaine is good. I'm saying that different amounts of cocaine are different levels of bad, and I'd like to understand what universe I'm in so that I understand it appropriately. I want to be factually literate. That's a good thing to know. Testing 2741, I was talking about the chat, loving the government, not you. Fair enough. Cody the Bum said $5. Some people are more concerned with ensuring Nick looks bad than thinking through the facts. Just ignore them, Kurt. Fair. Kylie said for $14.99 Australian, you're doing amazing, Kurt, and being neutral with your opinion regarding the law. I was a supervised contact worker for years, and it's amazing. Always challenging, let alone the legal side of it. Linda Richards for $2 said, thanks for even kill, Kurt. Appreciate it. Orville 9999 for $5 said, how well networked and coordinated are all your law tubers? Do you circle the wagons for each other, or is it more like a bunch of strangers? More like a bunch of strangers. We've discussed it at depth. Thank you. Arla7247 said $5. 5 Canadian dollars. Well, I was just thinking, I appreciate your coverage. Many tubers when touch subjects to do with fellow tuber acquaintances. Wrestler $2 says a reasonable analysis and explanation. Thank you. New York Renal MD has been a member for 29 months. Thank you very much. Lynn Britton has been a member for 11 months. Thank you. Nancy Kornesk for $2 says, thanks, Kurt, for your fair and emphatic take. Christine Huff has been a member for 10 months. Amanda Page has been a member for 12 months. Pandora Fox for $2 says, you've proven to be a very loyal friend first. I try to, loyalty is an important value to me. Loyalty is an important value to me. It's something that I value from my moral framework. So thank you. Enchilada Umbrella says, you're doing well with what you've had to work with. Reasonable. Dominique Fortin says, thank you for mostly unbiased and rational analysis, which is understandable because you're a distance to the subject, so please rest easy. Is there a time when ADHD drugs were still in short supply? Is that still the case? Hell yes. In fact, the government just posted an advisory about this very issue, that it's getting worse. The U.S. government just busted a mail order remote pharmacy operation, and the New York and the feds released a report saying it could impact people even more. Exciting news. Rebby Lee for 10 Canadian dollars says, from way back in the uncivil Rekieta drink-off days. Do you remember it? I do. I really don't want to drink anymore. I'm really impressed at your deposition. Thank you for saying this best. Stay strong. New York Reynolds MD says, nail analysis easily rules out smoke exposure. Fair enough. Metabolites of cocaine would not be there from smoke. I agree. That makes total logical sense. Adrian Angevine for $5 says, I worry about contamination. Labs are good, not perfect. Test covers a 3-month period. Can Nick request an independent test with new sample collection? I would presume so. I would think so. Yeah. I can't remember. Has been a member for 7 months. Florida Dad for $10 says, not full Robert Barnes on this, but after Karen Reed, I'm embracing innocent until proven guilty. You and Aviva are doing the best job at reporting this as neutral. I appreciate that. Robert Barnes is still incredibly wrong. I can't remember for 10 gift memberships. Thank you very much. Unforced Ego for $20 says, don't worry about the haters, Kurt. You've been open about your biases from the beginning. I always try to show my work every step of the way because I want you to be good educated, and I want you to understand where I'm coming from, and I want you to understand my thinking so you understand my conclusions. Jake from State Farm said, you're a good man. Your emotional struggles and evidence, as they should be for anyone concerned about a friend. Keep up the good work. Enchilada Unbreaded became an uncivilian. Jeremy Johnson said, if they smoked it, when all the kids have tested positive. We discussed that. New York Renal MD said, I don't know which kid is special needs. However, unfortunately, not the first time parents have used narcotics for special needs. Okay. That's a possibility I had not considered. That's a fair possibility. I had not considered that it could be a special needs thing, and the parents are trying to use street drugs to treat it. That is a non-zero possibility. Thank you for waking me up to that possibility. I appreciate it. Stephanie H said $4.99 said, thanks, Kurt, for your always honest breakdowns. Soul Souffle said for $9.99, it would not be unreasonable that addict parents would medicate an ADHD child with cocaine. Is similar effects of Ritalin on ADHD people. That this was information that I had not considered. If that is the case, then fair enough. If it actually represents daily use because the parents are medicating their child with cocaine, if that turns out to be the answer, I am going to be grumpy. If the correct answer to this conundrum turns out to be the parents are medicating their child on a habitual basis with cocaine, if that turns out to be the right answer, I am going to be extremely grumpy. Very. Yeah. Q Squared has been a member for 49 months. Annabelle Feinstein has been a member for 31 months. Pop444 for $5 says, we need more Cooking with Kurt episodes to make the world right. And Patricia Bell Dell gifted 5 gift memberships. Soule Souffle for $9.99 said group hug. Yeah. Yeah, if that turns out to be the answer, I don't know at that point how whatever friendship I have with Nick could survive that. I don't think it can. If the parents have been habitually giving their child cocaine, dude, man, that would be a whole nother level. But I'm going to desperately hope for an alternative explanation. So if anyone wants to propose an alternative explanation that makes plausible sense, now would be a good time. Jeremiah Johnson for $2 says, does that make Pablo Escobar an MD now? Cocaine is Schedule 2. You're absolutely correct. 100%. Cocaine is Schedule 2. Like Adderall and Ritalin, you are 100%. You are correct. Cocaine is, in fact, Schedule 2. As is meth, which we've discussed before. So yes, this is true. Cocaine, methamphetamine, Ritalin, and Adderall are all Schedule 2. However, some of these things are acceptable to give to kids under some circumstances, and others not as much. And so, although meth is also Schedule 2, if there were parents giving their children meth, I would not be happy about that either, because I do not necessarily consider them to be equivalent, regardless of how they're scheduled. This is just me. I don't think this would necessarily be equivalent. And pot is Schedule 1 for the moment, although they've proposed a final rule to make it Schedule 3. So, later this year, probably not. Jake, for $10, says, I have ADHD. Cocaine makes me energetic, happy, and chatty. Yeah. Meth is Disoxin, name brand. 100% true. You got it. 100%. You got it. Disoxin is methamphetamine. Disoxin is prescription meth. 100%. As New York Renal MD said, if you actually try to prescribe it, people will have questions. All ADHD meds make me depressed, miserable zombie. Highly, highly doubt this was intentional dosing. Fair. Lisdexamfetamine? Yeah. That's Vyvanse, right? I take Vyvanse. It's good. Why is my face so red? It is. It is. I don't know. Who can say? For those of you not following my community tab, by the way, I do have these great workouts that I'm doing and posting. And those are going really well. I went to the gym today and did some lifting. And so you can watch me do my workouts, and they've been very successful recently. Been having some great success there. Yeah, so it's good. All right, as long as I've got 2,300 of you here, now is a good time as any to talk about my merch store. So I'd like to sell you some merch. So we're going to do that. Okay. So let me bring that up. We have some cool stuff. At least I think we do. All right. All right, let me enlighten you with the Uncivil Law merch store, which has some cool shit. All right. I'm very proud of this. This is new. Here is the Uncivil Law merch store, which has the Uncivil Law logo and Callie the bee fish to welcome you to the chat. That's some good stuff. And let's just browse all the merch we've got. We've got some cool stuff. We got this uncivilian shirt in black. That's pretty cool. We got this mouse pad, which I think is particularly cool. I like this. Learning from the misfortunes of others. This might be my personal favorite item we sell personally. It comes in 18 by 16 as well as larger size, 36 by 18. And I think that's very, very cool. So you can have the learning from others mouse pad. I'm definitely getting that for myself. And also the Uncivil Law logo mouse pad in different sizes. We also have the Canton PD PSI set, the Canton PD forensics tools featuring a leaf blower, garden rake, shovel, and push broom. So you can learn more. So you can sport the Canton PD CSI stuff. We've got the evidence collection sticker, which is a red Solo cup sticker in various sizes. So that's cool. And what might be my second favorite item is the evidence collection cup in glass. So you get your own evidence collection cup. It is property of the Canton PD, as you can see, but that's okay. You can have your own for all your evidence collection needs. That is available to you, and I think that's my second favorite item because it's just not. How can you not like that? We also have a limited edition item, the Canton CSI badge holographic sticker, which, as you can see here, features a picture of a paper bag and a Solo cup as the logo, because of course it does. Fantastic. We also have a learning from misfortune mug and chat. We got an Uncivil Law glass and tumbler. We have the Taint Team Data Scrubber travel mug. If you want to be part of the Taint Team, you can have this mug with Kylie the bee fish to keep you company. And we got this nice little cowboy hat tumbler. That's really cool. Legal education with an edge. How can you not like that? Callie the bee fish sticker. We do not yet have the plushies, but that's okay. You can get a sticker in 5.5 inch by 5.5 inch form. It's holographic, so it shines. You can put it on your laptop. It's awesome. And learning from misfortunes others mug and some other mugs that we have. So we have some cool stuff. So please check that out. Consider buying something. I hope you enjoy it. It's some good shit. Yeah. So that is the merch store item. It's available through my community page on YouTube. And it should be, hypothetically, like right below the video too, should have some items you can click on. You need a plushie. Unfortunately, plushies are a bulk item. So we can't order them one at a time. I think it's like a 300 minimum order. And we are not selling enough merch for that right now. We are not in a position to make a custom order of bee fish. I presume that we would sell some of them, but I somewhat doubt that we would meet the minimum. And I don't want to be stuck with 200 bee fish, as much as that fun as that would be, because I have to pay for them. So if the merch store grows to a point, we will eventually offer a plushie. But in order for that to happen, we need enough merch enough often that it seems like a viable prospect. So we'll see. Do a pre-order for the plushies? We could. But I don't think it's viable right now. I just don't think we have enough business to make that work. I just don't think there's even enough to do a pre-order at this time. So, yeah. Someone in chat says I'm defending a druggie. Go F yourself. What's the origin of the beef fish? We've talked about it before. Will one of my mods hit exclamation beef fish, please? Do I have merch? I just went through my merch store. Yes, it's awesome. What do you think we've been talking about for the last couple minutes? Tug is here. Hello, Tug. I'm glad you're here. Tug's analysis has been very interesting on the subject as well. Oh, Tug is rating us. That's very, very kind. I appreciate that. Yeah, that's nice. Thank you, Tug, for rating me. That's very, very kind of you. I appreciate that. Guardian at Lightem says, Keisha says, Guardian at Lightem here and behind in stream. I can't tell you how many cases I got where drugs are involved. Most drug-affected newborns. Yep. I spent about 3 years with my kids during the process. Yep. I have no problems believing that. A lot of babies born with drugs in their system. It sucks. There's nothing good to say about that. And in many cases leads to lifelong health complications and developmental complications. It's a very insidious thing when it happens. Yeah, that's the check 1, 2. There it goes. Don't know what happened there. Sorry. It was not my fault. Something happened on the stream interface I'm using, which is why I don't typically use it. And I apologize for the muted audio. That sucks. How long was I muted for? 30 seconds? More? I hate my life. It was just as Tug came in. Please tell me I haven't been muted that long. About a minute? Thank God. Yeah, hopefully it wasn't that long. Yeah. Well, I do appreciate Tug's raid. That was very kind. It was everything I mentioned after mentioning its insidious thing. All I said after it was insidious thing, all I said after that was contemplating children being born with drugs in their system was making me sad, and I didn't want to talk about it anymore. That was all I said. And then let's move on to another topic because that was too sad, and I didn't want to dwell there. Asha Shaw JD said, "Read my super chat." I thought I did. I thought I read them all. I did read it. Oh, maybe I was muted when I read it. Maybe I was muted when I read it, so I'll read it again. Because I don't know how far to go back. So I'll just read them again. Emma Daisy for Australian 299 said Coke is greater than Adderall. No one's wasting money on that. I'm not sure about that because, well, Adderall is more readily available. Christopher May has become an uncivilian. Kathy Meyer became an uncivilian. Christopher May gifted 10 gift memberships, and Ada Shaw JD said, "We truly do not know people, even though those we call friends. So give yourselves a break. How would you have known? I saw you on STS and appreciate your insight." And then I said that I really enjoyed the panel on STS. It was a good panel today where we discussed Karen Reed, and I had a fun time, and I hope we can do it again. And I stand by pretty much everything I said. It was insightful. All right. Are there 2 Emmys? That's my understanding. And why? Well, because one of them at least has a credibility problem because, of the initial finding of undetermined. So I have no particular problem believing there's a second MD that would be there to confirm the work. I would at this point. So yeah, the fact there's 2 Emmys doesn't surprise me at all. Someone who double checked the work. It makes total logical sense to me. Surviving the Survivor, yeah, that was fun. It was a good one. Yeah. So what else can we talk about? Gotta go exercise, love your work. Hey, don't forget to check out my community tab. I post my workouts every day. I've been posting them for like a month. I do good workouts. You should check them out. And don't forget to check out my merch store. The fact we haven't heard from the Emmy is pretty crazy. I agree. That is very weird. The fact that they held off the lead investigator was so long was weird. The fact that the Emmy apparently is being held for last is very weird. It's like technically I still don't know what he died from. Because no one's told me within the confines of the case. That's a very weird murder trial. We're at the end and the state's about to rest, and I still have no idea how the person died. That is a very, very weird murder case, presentationally. No clue how he died. That's a very weird place to be. Not as weird as a murder case without a body. Fair. I mean, then you don't have an Emmy. So that's fair. Murder cases without a body are tricky. Yeah. Shouldn't the Emmy have been first? Not necessarily first, but early. Not necessarily first, but the Emmy is usually kind of early because, usually like the lead investigators first. I mean, that would be logical, right? You put the lead investigator on there, to lay out the scene and introduce the players, right? Because the lead investigator is who everyone runs through. So, the typical way to do this is the lead investigator goes first, and he's going to introduce all the players, and then you reveal the players as you go along. And the Emmy is typically relatively early, comparatively, and this is Bizarro World. Do I think Lowley's saving the best for last? For Lowley's sake, I hope that's the case, but I'm doubtful. If this turns out to be a mic drop moment for the state, then fine. But, I'm doubtful given what we know so far. I have serious reservations. Carrie says, you've come a long way since I started watching. You stopped the stream drinking. Your depression has improved and you're working out. You look much healthier. Thank you. I think that's true. I will by no means claim that my depression is over, but I will claim that my depression is better. I will claim that I'm better than I was, and I'm still on the upswing, and I'm still improving. And I will say that I'm in a better place than I was. And hopefully, if my efforts to take care of myself continue, I'll be even in a better place in the future. So I really appreciate that. And I appreciate all the compliments from people who say that, because they've said that, they keep saying that. And to be fair, and I've said this before, it isn't necessarily like always forward. It is not, because that's just not how that's worked. It has definitely been 1 step forward and 2 step back. And there's been times where I have slid down in my depression and reverted to some degree, but still overall, like, it has been a improvement, right? Overall, it has been an improvement, and it has been great. And it gives me hope that maybe if I'm really, really lucky someday, maybe the depression will go away entirely. Who knows what's possible? We'll hope for the best and keep working towards it, because why not? That would be awesome. How excited am I to see the witnesses from Tuesday's Voir Dire take the stand? If the judge does not allow those witnesses to take the stand, I am going to lose whatever is left of my shit. Yeah. Do cops need to prove competency like the experts? They're supposed to. Yeah. The rules for an expert witness are the rules for an expert witness. They don't change magically because they're cops. That's not a thing. If the cop is there to offer an expert witness, he has to be qualified. If he's there to offer an expert witness, yeah. So, yes, at least in principle. But no, apparently in practice. Because there's no way, if there is a lawyer in this country who can honestly say that they think Trooper Paul meets Dalbert or Fry, I'd like to meet that attorney, and then I'd like to punch him in the face. Because he obviously needs the wake-up call, and I'm here to help. All right, where are we on this thing? All right, so I think it's time to stop the chat. We've done good work. We've been here for a while. I mean, the physics stuff guy. Yeah, that's true. Yeah. That's fun. Who or when does a grand jury decide if a case goes to trial? Grand juries are very easy. All you need is probable cause, and you only need a majority of a grand jury. So getting an indictment from a grand jury is pretty easy. There's that old saying about you can indict a ham sandwich because it's kind of true. Typically, a grand jury is 23 people, and you need only 12 of them to agree, and you only need them to agree to a probable cause standard, which is very low. So getting an indictment out of a grand jury is pretty easy because it's a very, very low threshold. And most states don't use them at all. Well, half the states don't use them at all. Of the remaining states, some use them for like really high profile stuff. And, there's a smattering of ones that use it for other stuff. But like, grand juries are kind of stupid. They're dumb. So I will end the stream by once again pitching my merch because why not? I can use the merch. Please visit my merch store. Will my mods please spam the chat with the link several times as I'm wrapping up the stream? Please check out my merch store. We have some really cool stuff that I'd like you to check out. We've got this cool Learning from the Misfortunes of Other mouse pad I particularly like. We've got the Red Solo Evidence sticker. And we've got the Red Solo Cup glass for all your evidence collection needs, because that is just way too funny. You can get your hands on the Evidence Solo Cup, a 100% glass tribute to the Canton Police's brilliant choice of unsanitary solo cups for blood collection samples in the Karen Reed murder trial. How can you not love that? How can you not love the Evidence Cup? It is best cup. You know you want it. Go buy it. And we also have this nice tote bag, which is I've got my logo. It's got the cowboy logo plus my regular logo on the other side. The limited edition Canton CSI holographic sticker, which has a picture of a brown paper bag and a solo cup on it, because of course it does. So you can get that and have that in your life. You know you want it. And also we have the Learning from the Misfortunes of Other mat. We've got the cup. We've got the shirt. We got the Taint Team Data Scrubber mug. If you want to be part of the Taint Team, Callie the Beefish would like to introduce you. And she is here for it. We got Uncivil Law mugs. We got this cool Uncivil Law tumbler. The logo is easier to see on the shirt, so I'll show you the shirt first because it's got this cool Uncivil Law logo, legal education with an edge. That's pretty damn cool, if I don't say so myself. And then we got the mug, the travel mug, which has got the exact same logo. That's pretty cool. We got a Callie the Big Fish sticker because we don't have the plushie yet, but that's okay. You can get a 5-inch by 5-inch sticker, and then you can put it like on a laptop or a notebook or whatever, and that's wicked cool. And you can tell all your friends about Callie the Bee Fish, the abomination that it is. And we got the Uncivil Law mug, which is very nice. And we got some other things, learning from the misfortunes of others mug, which I personally like, plus the Callie the Bee Fish wanted poster monk. That's nice. Wanted for shenanigans because, of course, Callie is. All right, with that, I'm going to go ahead and sign off. I've been Uncivil Law, and I hope till later, my friends. You have a great one. Stay safe out there until later, my friends. Keep it real, and goodbye.